The judge identified who the injured party was and repeatedly addressed its mind to who stood to lose in this. I think identifying the question of who the injured party was of necessity then deals with the issue also of what the relevant principles to apply is. It seems to me that even though the court identified properly who the injured party was, the court went ahead to apply the standard and the orthodox principles of injunctions to this, one of which being the question of the adequacy of compensation by way of damages in the event that the matter goes in one direction or the other. I think that the principles of damages which are normally applied when it comes to the question of injunctions, damages and convenience and those standard principles, and the court invoked the case of, relied on the case of Owusu and Owusu. It seems to me that those are extremely inadequate in matters of constitutional principle, constitutional injunctions. And I think the court was handicapped because, frankly, over the years, the court has been applying the orthodox principles of injunction to constitutional principles, or rather to constitutional matters of injunction. And I think that for the first time, the court actually addressed its mind to who stood to lose. In my opinion, I was quite excited, actually, when I saw that the court addressed its mind to that. I was hoping that the court would have then gone ahead to construct unique and standard principles for deciding matters of constitutional injunctions, and indeed what the standard thresholds are. In other jurisdictions, they've devised things like what you call the heightened scrutiny in determining matters of constitutional rights, among others. Now, the reason for heightened scrutiny is that the courts would then, for example, require higher standards of proof from a party making a claim. The courts will require that the determination of balances of rights and liabilities are looked at very carefully. And the court considers, among others, what lawyers would normally call sui generis principles, that is, principles that are unique to that particular case. So I was very happy to see that the court was alive and active in terms of its thinking to the peculiarities of the case. However, the application of the principle itself ultimately ended up with the standard old orthodox principles that we've always had in regular injunctions, in matters involving parties where a party would have gone and sought from the courts the freezing of rights in the meantime, pending the determination of matters. And those ones, in my opinion, respectfully, I think fall short of the standard high principles that ought to be expected of a party or parties when it comes to the decision on matters of constitutional rights.
The court should not have granted the injunction. That's your point.
No, I haven't said that. I haven't said that. What I have said is my expectation was, having then identified or having then shown consciousness of the peculiarities of the case, my expectation was the principles, I expected the application of the principles to have conformed to the peculiarities. Maybe the court should have seized the opportunity to have erected new principles in this place. But in terms of the substantive
application
or the refusal of it,
if the application, as you say, had conformed to those standards, the injunction would not have been granted.
No, it simply means that the party who argued before the court asking for the injunction perhaps would have been expected to show certain proofs which invariably may have been higher than the standard proof.